We're good to go? Okay. Hello. Afternoon, everybody. Nice to see you all. Hi. My name is Jeremy O'Hare. I'm an information expert at the British Library Business and IP Centre. Thanks for the opportunity to invite me here today to speak to you. I'm going to speak to you today on what on the surface looks like one of the more boring topics you could ever imagine, but actually when we dig underneath the surface is absolutely fascinating and I guarantee directly relevant, I hope, to you today as business students, and I'd imagine many of you are looking at, or if you haven't already, starting a creative business of one sort or another. So this topic that I'm going to talk to you today, I hope is going to be helpful to you. I work at the British Library. I've been there for well over, 15, 16 years. So I've worked with hundreds and hundreds of different businesses, helping them to start, to grow, and to make intellectual property a real centerpiece of their business, and helping them to succeed and eventually employ people and all the rest. Hopefully something that you'll be able to do in the future. So this topic is massive. I've got a limited time till about 2 o'clock, so I want to honor your time and keep to that. I've got a whole bunch of slides, but I promise you it's not death by a PowerPoint. I'm going to be going through pretty quick, but what I want to do today is just give you, not compromising any details, but give you like the essentials that you really need to know about IP and how it's relevant to you. But forgive me if it's a bit quick speed on the deck here, changing over, but we'll go through. I'm not an IP attorney, straight off. Legal questions, we can talk to lawyers, and I'll give you some guidance on that after the session. So, what is intellectual property? So IP is essentially creations of the mind. Things that you create could eventually become property which you can use and earn revenue off, or give away, or donate, up to you. But it has to be a creation of something. IP is not just something in your mind, it has to be expressed in some tangible form. And I'll go on to explain what that means in a moment. So here's a legal definition of IP, because we touch on some legal stuff today. IP law regulates the creation, use, and exploitation of mental and creative labor. There are two sides to it. There's the creation and commercialization, and there's a protection from theft. In the same way, you don't want someone to take your stuff. That's theft, it's your property. Exactly the same principle applies to IP. You don't want someone to take your brand or your products or any other creation that you have. You want to keep it and use it and make the most of it because it's your creation. So IP, two sides, commercialization and protection. So let's get down some examples of what I mean by IP. These things are every day. Every day we're using things on our devices, we're consuming stuff, music, we're watching shows on Netflix, we're using technical innovations every day, we're buying stuff from clothing manufacturers to food, to everything. You can't escape a brand. So trademarks and all these things are all over the place. So here's examples of different types of expressions, creations, and here's where IP kicks in. So there is a family of intellectual property protection. IP is like the umbrella term, but there are different types of members of that family, different types of IP. And we're going to be looking at each of these different types of IP in turn today, just so you know what you're looking at. So when you start or grow your business, you know that you've essentially got a menu of options you can use to protect whatever the thing is that you've created, be it software, a product of some sort, whatever. So let's get a bit more real with how a massive company like Coca-Cola uses IP. And I use this to illustrate, to give you some more grounded examples, but you can apply this potentially to whatever business you're looking at doing. So we have here the famous Trademark, well over 120 years old now. Coca-Cola own that brand. And could you even put a price tag on the value of that? That gives them absolute control over who can use the C-O-C-A-C-O-L-A swirl. It's an iconic logo, something of huge value. In fact, it really represents the sum total of the company, you could say. To put a price tag on it would be almost impossible. Here on the can at the top here, we have the can opener, which is a sort of a ring pull mechanism. There is a patent behind that. There's a trademark behind the brand. There's a patent behind the opening of the can. That's a technical innovation. Here in the middle, we have a registered design. This is covering the design of the bottle, and that was registered back in 1916. It was one of the very, very earliest examples of product packaging and registered design with that. And they still have ownership over the rights of that design. If you were to take away the label and just look at that shape, you'd recognize that that is a bottle of Coke, even without the logo on it. Such is the power of design. Over on the right here, we have a piece of advertising literature from the early 20th century. Coca-Cola owns the copyright to all of their old marketing campaigns. They can repackage that, rehash it, reproduce it, reuse it in whatever form they like. Be it selling fridge magnets, T-shirts, whatever you could imagine. Because they own those images, they can license them and earn revenue off it. So it's a big money spinner for the company, especially as they get older. They've got heritage, the value of their brand increases, and what they can do with all these old creations of theirs. The sky's the limit, really. Perhaps many of you would have guessed what the question mark relates to. It's a trade secret. So it's copyright there for the older material. Trade secret here, the question mark. And that is the recipe to Coca-Cola. That is only known within the company. In fact, a guy called Dr. Pemberton came up with the original formula, I think back in 1892. That was kept within a very close circle of people in the company. Then written down in 1919, actually on a piece of paper, and then deposited in a bank vault in Atlanta, Georgia. So the recipe for Coke still exists on a piece of paper, but now I believe is in the Coca-Cola World Museum in Atlanta. If you go there, you can see the safe on display and this sort of mystical recipe, which is hidden behind a locked cabinet, a locked safe in the museum. And that's an example of another form of IP, trade secret, which, by the way, I think is a really kind of helpful piece of branding. It really helps with the heritage of the brand to have this trade secret. Not on this list is something called know-how, and this is over 120 years of trading experience and knowledge that the company has acquired, just selling their fizzy water, basically, all around the world. And if I was to start a new business making fizzy water, I'd have 120 years to catch up, potentially, with all of the skills and the experience that company has acquired. So that's called know-how. That's another form of intellectual property. So to recap, trademarks, patents for the opening of the can, designs for the bottle, a copyright for the advertising material, and a question mark for the trade secret, and know-how as well. Just FYI, if you're interested, that's an original patent specification for the ring pull can opener, just there, 1969. That was filed as a patent. So another really important thing about IP is that because it's property, essentially, the things that you create, all of these different expressions, you can rent it out, also called licensing. You can give it away, you can assign it to someone, or you can buy other forms of IP. You can buy other people's creations as well. And it's an asset that grows in your business. So as time goes on and your business gets bigger, has more value, IP is an asset that will grow your business. So eventually, if you want to sell your business, you can also sell your IP. In fact, it's quite an important part that any buyer will look at when buying a business. Okay, so I'm just going to dive down into a few more specifics. I want to make it relevant to you and to the sorts of things that you might come across with IP. So I'm just going to kind of skate across a lot of the detail, but I'm not going to compromise on the important things you need to know. But this is just kind of helpful for us to kind of get our heads around these 6 different members of the IP family. Half of them are what we call registered rights, and the other half are unregistered or automatic rights. So the registered rights basically mean anything that you create, a patent, a trademark, or a design, you register with a government body called the Intellectual Property Office. It's a registered right. And they will approve the application, and you get a certificate saying you own the trademark or patent or whatever else. The other half of the IP family are unregistered rights. Copyright, trade secrets, know-how. So as soon as you create one of these rights, as soon as I've finished my novel that I've spent 10 years laboring over, as soon as I put the last full stop on the page, I can claim it as my complete creation. It's automatically mine. I don't have to register it with anybody. I just have to prove it was me that created it. We'll go into more details about that in a moment. Trade secrets and know-how are things that you keep within the company. Again, unregistered rights. You don't need to tell anybody that you've got a trade secret. So that's registered, unregistered in a nutshell. Also, just something important to realize, the IP rights are global. There's a lot of similarities between countries around the world. We recognize each other's IP rights, but there are some differences. Too much detail for me to go into on that point, but do bear in mind if you're going to be selling stuff, trading abroad, you will need to look at what IP protection overseas you need to go for as well. That's massively important, and that will potentially increase the costs that you might incur as well in protection. So, just a few exceptions. Scientific theories, mathematical formulae, business models of concepts, so you can't protect the business model, things in nature, older things in the public domain which anybody can use out of copyright stuff are exceptions to IP. Okay, so now, that's the what is IP. Now we'll go into the how of how we protect the things that we create, looking at each of these different members of the family in turn. So I'm not going to spend a lot of time on patents because I'm probably sure that not many of you will necessarily be having any technical inventions of any kind, but I don't want to assume anything. But just for your knowledge, this is what a patent covers. A lot of people get confused with, can I patent my trademark and so forth? They're completely different things. So a patent protects an invention. That is how something works or how it's made. To get a patent, it needs to be new, never ever been seen before in the world. It must be non-obvious, so it must be an inventive step of some kind, and it has to be capable of being made by some other people in the same industry that recognize it as being inventive. So better, cheaper, or different. Now, there are about 100 million patents in the world. They expire after 20 years, so if you apply for a patent, you get a monopoly for 20 years, and then it becomes public domain. So, for example, the patent on the zip was, I believe, granted again around about 1916, early 20th century. That's now public domain. Anybody can use a zip for their clothing. Likewise, Velcro, that was another innovative creation. That patent is now expired. Anybody can use Velcro in their clothing designs or whatever. So you do get a limited time, a limited monopoly to use on a patent, and then it's anybody's. So this one here, any guesses as to what this patent might be? I'll step back so you can all see. You probably see it on the street sometimes. That is a Brompton bike. That's the patent for that. The patent in the middle is a very early patent for a windscreen wiper, way back in 1903. And it was a female inventor that created that in America. And this is the patent for the biro pen, ballpoint pen, basically. Here is the ball, there is the point, there is the ink going through, the ball spreads the ink on a bit of paper, there's the inventive step, that's where the patent is. So millions and millions of these things filed and approved. I would say only a very small percentage are actually commercially viable and successful, which is really important because if you're gonna go down the patenting route, you wanna make sure there's a market and demand at the end of it all before you spend all the costs involved in applying for it. More on that in a second. So these are things that can't be patented. I'll just leave that there for a second so you can read. Things that you probably expect. Here are the advantages of a patent. Monopoly for 20 years. Other people can't use your technical invention. And you're protected as soon as you file at the Intellectual Property Office. You can then choose to file your patent in other countries around the world. You get up to a year to do that. So as long as your invention is really commercially valuable, you've got that monopoly, it's worth looking at for sure. However, there are downsides. Full application can take up to 5 years to get approved. And when you get that granted patent, that's your piece of paper saying, I own this invention. You may need to pay the costs of infringement. So all the legal costs of that are on your shoulders. So if someone, a larger company, uses your patent without your permission, you have to take them to court. That cost is on your shoulders. And your invention will eventually be disclosed, so other people will be able to potentially see it and maybe innovate off the back of that and create something new and leapfrog you. So that's a complication. And here's the thing, patenting is expensive. It's the most expensive form of IP protection. At least £4,000 in the UK with legal fees. If you're going to be patenting all around the world, you're looking easily at £50,000 plus. So serious stuff. You really want to do your research before you go down this route. So next form of IP rights are registered designs. This might be a little more relevant to some of you here today. Registered design comes in different forms. We've got industrial design, so that's products, urban planning, graphic design, product design, packaging design, even costume design, fashion, absolutely, stage design and packaging as well. Just to give me a sense of what your interests are there any potential designers here going into a design business in the future? No? Fashion or anything? No? Okay. Okay. Okay, awesome, great, great. So this could be of interest to you if you're designing a product, for example, maybe on the graphic design side of things. What you want to know is that you can actually get a registered protection for, let's say, a piece of furniture that you design or a new product of some sort, a toy or whatever. You can file that with the Intellectual Property Office so long as that design is distinct and unique. You'll be able to get it registered and recognized, becomes your property. You have a right for 25 years to own that design before it becomes public domain. And then you can start making it, manufacturing, and it becomes something valuable in your business potentially. Just to underline the value of design, here is a clock face, which goes back to the 1940s, designed by the Swiss rail company, SBB, recognized as an iconic form of 20th century design, this beautiful kind of modern clock face. Apple used that clock face on their phone, and there was obviously a dispute between Swiss Rail and Apple, and Swiss Rail said, we own that design, you're using it, and Apple very rarely said, okay, let's cut a deal. They didn't fight them, they said, okay, let's come to a deal. They got a license from the Swiss Rail company of $21 million to use that clock face on their phones. Because when we see that, we think perhaps of the Apple more than the Swiss Rail company. So it goes to show that something as simple as a clock face design could be worth millions and millions and millions of pounds, dollars, whatever, depending on the context and the value and everything else. So just to underline that point, potentially what you're designing could have massive value. So to keep ownership of it means you might at some point be able to use it and make money, exploit it for the better. So that's a really interesting case of that. And just as an aside, getting a bit nerdy here, the Swiss Rail company also took a trademark on that to get longer protection in the design. That's where it gets a little bit more interesting and complicated. You can kind of play around with the different options and maybe go for a trademark to extend the registered design and so forth. Well, I won't go into details, but there are ways you can use different members of the family at different times to maximize your protection, as large companies like Disney and so forth are very, very good at doing. Here's another example here. We look at our tablets. This was new technology, 15 years ago, if that. And a big dispute between Apple and Samsung over who owns a rectangle, basically, is what the battle comes down to. Apple, feeling particularly litigious at the time, took Samsung to court over the use of Samsung, one of their early tablets. They said, oh, that's a direct copy of our iPad. Apple were claiming $2.5 billion in lost sales and tried to put a freeze on any more of Samsung's product going to market. So a massive legal case. Apple, long story short, Apple lost in the long term. Samsung's challenge was ultimately upheld, but they got some limited protection in the US nonetheless, which just goes to show if you're big enough, you can kind of make the system work for you to a large degree. And that, unfortunately, I have to say, is the reality of the IP system. It cuts both ways. You can enjoy, as it were, the same protections, but in reality, the bigger you are, you've got legal departments, you can push smaller companies or other bigger companies around. But at least in the eyes of the law, these things are recognized as, there are principles that guide even between the largest and smallest competitors, that principles of fairness that needs to be applied. But nonetheless, here's an example here. Anyone seen 2001, Space Odyssey? Yeah, great movie. Recognize that device? Perhaps Apple were being a bit cheeky in claiming that they were the first to get the tablet when Kubrick got there, arguably before Apple. Which brings us to the next really interesting point around all of these things. We'll get into more detail on copyright. Design, you want to make sure your design is original. I'm sure Apple were aware of the prior art that this had existed before, but they pushed ahead nonetheless. A good thing to do is look for registered designs yourself. I'm from the British Library. That's what we do. We help researchers. We can help you do design searches. And come back to me afterwards if you want to do that. I can give you some guidance. We run separate webinars, etc. on that. But you want to make sure your design is definitely original before you push forward with registering it. And happy days. I'll get to that in a moment. By the way, it's a lot cheaper than a patent. We're talking 60, 90, depending on the number of designs, pounds per design registration. So much, just so you know. Another example here of design. Anyone recognize the Trunky here? Yeah, brilliant product. Traveled recently with my daughter with it. A big case here in the UK between Magmatic and PMS International. Magmatic owned the Trunky trademark, the brand. So these guys, PMS, they took the design, arguably, and made their own version, a cheaper budget version. And so Trunky took them to court here in the UK, and they said, yeah, fair play, we're inspired, we've seen a Trunky, we're inspired by it, and we're going to create our own version of it. And there was a ruling here in the Supreme Court around who infringed who, and actually it was decided that there was no infringement, which is kind of curious, because I don't know about you, when you look at that, do you think they kind of look similar? Yeah. And the makers of PMS, they admitted that they were inspired by Trunky. So what's going on here? How did they win that case and Trunky lost? They got there first. Unfortunately, the devil is in the detail with a registered design. This is their original application they submitted. That's an image from it. They're a little bit too specific in their registration and their actual designs that they submitted, and that's what the judge was going by. Registered design, the broader you can get around the shape and the contours, the better. The more detailed, ironically, your designs, you're kind of narrowing your options. So this is what the ruling from the judge and what lawyers have kind of commented on. The images define the scope of protection afforded by registered design. All features of the design shown in the images. So less is more, basically, if you're submitting a registered design. Avoid color, contrasting tones, shading, etc. But an IP lawyer would help you on the details of that if you are submitting a design at any point in the future. So the pros. It's cost effective, a lot cheaper. If it becomes famous, you can license it, sell it, and you can prevent other people from copying as well. And the cons, I'm sure you've realized, is that it's actually not too difficult for someone to take a design, innovate off it, create something new, and get a new design. So your protection is a little bit, sometimes limited as well. Okay, so moving on to the next one, trademarks here. What is a trademark? I would suggest that whatever business you're going into, you will definitely want to look at applying for a trademark. I'm sure you're all studying brand in your classes. The brand is more than just the trademark. The brand is kind of like the sum total of who you are as your business, your values, how you speak, how you communicate, the kind of personality, if you like, of the business. But the trademark is the sign or the distinguishing name or element that kind of represents or is the brand. And it has a long heritage. It goes back, well, actually pre-1800s, when we're thinking of really old kind of guilds and things that existed where you had like a seal of approval on the craftsmanship of work done in, you know, the traditional industries, tailoring and metalwork and so forth. And then eventually we got to the modern age, the trademark came into being, and with lots of different products and goods floating around, we wanted a trademark to distinguish one from another. So it's all about being distinctive and not having any confusion in the marketplace. So again, a trademark is, it represents who you are, and it gives a consumer confidence that they know what they're drinking. What's in the tin, for example here, Coke versus Pepsi, you can argue what's the difference, but really the big difference is this thing here, the trademark, the brand, what that is. Same product, completely different trademarks, completely different brands. So again, that's the value of a trademark. You can coexist with other people doing similar stuff, but your trademark is what's going to represent you and distinguish you from your competitors as well. And the bigger your business gets, the more customers you have, the more kind of brand share you get, the value of a trademark increases. People want to own that thing that you have, the piece of paper. So a business like Unilever here, it's like a house of brands. They own all of these trademarks. They can buy and sell, you know, a Surf. Who would have thought they owned Magnum, you know, Coleman's mustard. It's more than just a product. It's the reputation of the brand that people are buying and selling and licensing. And the good thing about trademarks is they can last forever in theory. So patents 20 years, registered designs 25 years, trademarks forever, so long as they are still active and they're renewed every 10 years. This is a great pub quiz question. The very first registered trademark in the UK is Bass Ale, way back in 1880, I believe it was. Here it is, featured in a painting by Manet. Their brand is still around today. It's been owned, passed on, sold to different brewers over time. It's still used today. Trademark number 000001. I kid you not, the very first trademark in the UK. So if you want to have a brand for your business, which I'm sure you'll want to make sure you're not infringing on someone else's brand. So we can help you with that. You can do this yourself even. This is the website you can go on to do a search for existing trademarks, the Trademark Register. It's publicly available, and you can make sure your name, your brand name is free for you to use. Another thing around trademarks, a common question is, can I have the same or similar name as someone else? Potentially, yes, so long as you're in a completely different trading classification. In other words, there's no confusion in the marketplace potentially. So we have here Swan Irons, Swan Matches, Swan Rentals, all with the word Swan, all very, very different classifications. And getting into detail here, but when you file a trademark, you specify one of just over 40 different numbers, and that's the classification you file your trademark in. It's called the NICE class marks. I won't go down a rabbit trail now, but just so that you know, you would need to choose one or more industry classifications where you register your trademark, and you need to make sure you're not infringing anyone else's existing trademark in those classifications. Again, we know IP is global. If you're going to have a global presence, if you're trading in Europe or in America or Canada, you want to probably register your trademark in those territories as well. Your prices will go up, but you'll protect your brand in those territories too. And it's a sad fact of life that the bigger you are and the more well-known you are, the more likelihood someone's going to copy you and imitate your brand one way or another. So there are grounds for refusal on trademarks. The bottom four here are pretty obvious. Anything offensive, anything using other people's images, it makes sense. The one at the top here, using words that describes the product and service, is the most common mistake when people file a trademark, just so that you know. If I try and file, if I have a business making cakes and I register a trademark for Tasty Cakes, I'm sure that would be rejected because it's too descriptive. What right have I over that phrase, Tasty Cakes, anyway? If I put Jerry's Tasty Cakes, there's a higher chance that will be approved by the Intellectual Property Office because it's distinctive and not descriptive. So that's a really important principle when thinking of your trademark. A nonsense name or a name that is neutral, doesn't mean anything, is by far the safest. Google, for example, and actually I don't think they even have a trademark, Google, because they're so big they don't need to. But it's a good example of a nonsense name or a word which is just made up. Those are the better trademarks sometimes to have, depending on your industry. Yeah, so obviously bad faith, we call that passing off when you have imitations. Accept no substitute. This is why the value of a trademark is so valuable, Nutella. And we see here, they are in a circle, registered trademark. They can shut anybody down that potentially wants to copy or infringe their product name. Many of you may have seen TM as well. We have an unregistered right in the UK. From today, you can upload a website and have a business name or sell a product, put TM next to it, and you can start trading. But it's not as strong as a registered right, not as strong as filing a trademark with the Intellectual Property Office, because you get that certificate, you get the R, you can put that legally on your name and it becomes your property. Essentially, you can sell the trademark, license it, whatever. And here are obviously everyday examples. I want to pick out two here. Bacardi, when you file a trademark, you can file for the name and also an image, so a logo. You can do both, either or both. And with that example, I think both are strong, the name and the image we can recognize. Likewise, the Superman icon here is an astonishingly valuable trademark. If you own that trademark, basically it's a license to print money. When you think of all the t-shirts and merchandise using that S symbol, that is hugely valuable. So again, it just shows you what you can do. It's your property. You can license the image to different people, that licensees that want to use it. Massively valuable. So yeah, don't underestimate the power of trademarks. Again, it could be an image, it could be a name, it could be both. I would recommend, whatever you do in your ventures going forward, seriously looking at getting a trademark and building your brand from the very beginning. And the good thing is, if you get it right now, it's going to last you much longer in your business life. You will have avoided making some costly mistakes further down the line. So I'm going to be finishing off here on copyright. And I expect that for many, many of us here in the room today, this is going to be the IP right, which perhaps most of us will have some involvement in potentially. Designs and trademarks, absolutely. Less so maybe designs for some of you. Trademarks, absolutely, but copyright. I heard there's a photographer here in the room. This is really kind of important stuff. So the value of copyright, is huge in the UK, estimated at 30 billion. It's 2% of the UK GDP have some kind of creations of stuff which are copyrightable. When we think of the gaming industry in the UK, the film and TV industry, it's absolutely massive. All of these industries are in some way or another using copyright as their primary form of IP protection, along with the other stuff, trademarks and designs potentially, but copyright is absolutely massive. So what does it actually protect? You could say everything else apart from what I've mentioned, almost. So here it is. Literary, dramatic, musical, artistic work, illustration, photography, a lot of illustrators here today potentially. Non-literary work, so software, if you're creating an app or any kind of software program, that's really, software will be what you're going to be using, copyright rather is what you're going to be using. Sound and music recordings, all covered by copyright, film and TV, broadcasts, even the layout of books, how you lay out your designs and your images and wording and so forth is actually covered under copyright. It's an associated right that goes with that. So what are we talking about? In order for something to qualify as being copyrightable, it must be, like other forms of IP, completely original, never been seen before. It's your own creation. As we know, it's an automatic right. As soon as you create it, you own it. And it gives you a lot of rights over usage, a lot. You can really object if someone uses your illustration or your photo without your permission, because you've created that. It's your property. You can stop people from stealing it, and you can get some sort of financial compensation if you're being affected. So it's a really important right. And as we've seen with IP, it's property. You can sell your copyright, donate it even, or license it out. And it protects tangible items, but also exists independently. So, if I was to buy a book, I don't own the copyright to that book. I may own the book. I can sell it to someone else, but I don't own the creation of the words and the images that are inside that book. It is owned independently, usually by the publisher. So it's independent of the fact that I own a physical thing. It exists somehow kind of out there as a concept. Nonetheless, work must exist in material form. So, it's all very well to have an idea for a screenplay or a book, but it's not until I put those words on a page that then copyright kicks in. I've got something tangible that I can protect, whether I draw or design or whatever. The same thing applies. So here's the thing. Copyright lasts quite a long time. So it's the life of the creator or author plus 70 years. So that's a significant time. So we have a lot of kind of famous works that are still in copyright. Tolkien's works still in copyright. He died in the 60s, I think it was, if I'm not mistaken. His family owned, his descendants owned the rights to that. Pablo Picasso died early 70s. All of his children have rights over his work, all of his back catalogue. There's a company in France which manages the estate of Pablo Picasso. Why? Because his work, all of it is in copyright for another 70 years after his death. So, if you're lucky enough to have someone in your family who's got something valuable, you can enjoy the benefits if it's been assigned to you. So it's an important right, and it lasts a while. Typographical right, the arrangement of pictures in books, that's 25 years. Broadcasts, 50 years. And sound recordings, that's been extended to 70 years. I call it the Cliff Richard effect. As soon as these kind of aging rockers get older, the old 50 years copyright is getting a bit, when some of them are writing songs in their late teenage years, early 20s, they're getting to retirement, they're looking at their pension. The law was altered recently to allow sound recording for 70 years after it was first played. So these aging rockers get to enjoy a little bit more of their creations over time. They get a license every time the music is used or whatever else. In fact, there's a big trend in the music industry now where artists of a certain age are now cashing in and selling all of the rights to their songs to big companies, which can then kind of maximize the music as a product be it through streaming or advertising or in films or whatever else. Sting is the most recent example of this. Only a month or two ago, he sold all the rights to his music to A&R, I think it is, and they basically own everything. And for a nice big cash payment, I'm sure, which will keep him happy for the rest of his life. So, how do you protect your copyright? This is embarrassingly naively simple, but I'll explain it, and it's a bit crazy, but let me explain. So, as soon as you create your thing, your illustration, your photo, whatever, you can put a C in a circle, or your web page for that matter, C in a circle, your name or your business name, and the year of creation. You are then kind of staking your claim as I own this is my copyright. So you want to keep a physical record of some sort, but the thing here you must be able to do is to evidence you created what you did when you did. So it's all about date evidence. Super important. So this is where it gets interesting. This is still a method. Never been tested in the court of law, by the way. But you can, for example, post things to yourself, registered post in an unbroken, in a sealed envelope. Why? Because that evidences the date of when it was sent through the postal service. You can, and maybe preferable, if you're really serious, is to file a copy with an IP solicitor or any other kind of solicitor for that matter. They'll put it on archives, they'll stamp it as received, they have a date there. Now you might think, hang on, this is crazy. We're in the digital world. Why can't the date on my Word file or my, whatever program I'm using be evidence enough? Well, maybe, but actually software can be manipulated, dates can be manipulated. So having a kind of a traditional way of marking a date stamped, as it were, is not a bad thing. That being said, there's blockchain technology these days. There's ways we can evidence creations digitally. I'm not aware of that being tested in any case yet. I'm sure it will be at some point in the near future. It's an evolving thing, evidencing digital files. There was a service, beg your pardon, from World Intellectual Property Organization called Iep Proof. They shut down only a couple months ago, but there are other online services where you can register digital files as proof of dating, of date stamping rather. The one that I would recommend, as I know is being reliable, is an organization called ACID, Anti-Copyright in Design. They have this service where you pay 2 or 3 quid and you register the file, the software file, and that gives you a date stamp as being recognized as when they received it. So that's a thing. Just so you know, it's all about the date. Because if you get into a dispute with someone, you want to prove that you got there first before they did. It's all in the date. So as I mentioned, you have a lot of rights as copyright holders. Here's just a few of them, depending on the type of expression. Renting, lending copies of your work, performing. If you're a playwright, you have rights over whenever your work is performed. You have that. If it's a digital creation, you have rights over every time it's being played. Every time it makes an adaptation of your work, you actually have rights over it. So for example, I write a novel, someone translates it into German, I still have a right to earn something off that translation because it's considered an adaptation. Likewise, if my novel gets converted into a screenplay, that's considered an adaptation. I still have some kind of parental rights, if you like, over that original work. So you have a lot of control over how your work can be used. Of course, it prevents copying in any way. Everything else here mentioned, you can see. So when it comes to managing your copyright, always make sure the situation is clear up front, whether who's the owner and who's the user rather. An assignment is really important as well. I'll go into that just in a moment. And here's how you make money from your copyright. It's all in the licensing. And it all comes down to a commercial contract. You can have an exclusive license to someone to use your creation, be it your photo or whatever, or you can have a non-exclusive, meaning anybody can take a license out on a picture, for example. You can limit the time frame on that license. and other rights as well. So it's all in the licensing. So an example is software protected by copyright. Why? Because it's a string of numbers and letters. Whenever you click in and you agree to an app or a software, essentially you're agreeing to a license agreement. The copyright owner of that software is allowing you, a licensee, to use it. And if you ever are bothered, which I never am, would never be, you'd be mad unless you're a legal expert, to read the details of the terms and conditions of your app or your software product or whatever you're using, there will be large sections around IP in that agreement that you couldn't resell the software or whatever, or make copies or whatever else. So licensing is the thing when it comes to copyright, and I'll get more into that in a moment. Now, here's something really important, and I must stress this. I think there might be potentially some freelancers here today who are going to be doing other work for people. I've got great news for you freelancers. You own your work. You own your photograph. You own your design for the logo. You own whatever it is you're creating for the person commissioning the work. Now, they may come to you and say, I might be a business, and I might say, okay, can you design me a logo? But I would like for you to assign the intellectual property to me, the person commissioning it. You as a freelancer can say, yeah, that's fine. I'm fine with that. I will assign my IP rights to you. But unless that's done, you still own the rights over the design. That's the default position in UK law. Very famous case. They're so cliche, I know, but it is a good example. Innocent Smoothies, the halo design, they got into real trouble with this because when they got big, and the brand was everything with that, well, it was a significant part of the product, was the brand, the designer said, hang on, you're using my design. They said, well, we paid you for the design. We have rights over it. And the designer, the graphic designer said, no, I never assigned the IP to you. And the designer won their case. The assignment was never made. And so a deal was made over shares in the company, and eventually that designer got their reward, and rightly so. Everything the designer said was correct. So I'm looking at it more from the point of view as you as freelancers. Be aware that you have your rights around this. If you are working for someone, part-time or full-time, the employer owns the IP. The situation is reversed. So this wonderful presentation I produced on behalf of the British Library, my organization owns this. It's my time, my sweat, but it's done in the course of my employment. They own it. No, fair play. That's how it works in employment law and IP law. So can I use other people's copyright? Always best to ask for permission. Make sure you credit. There are exceptions to usage. I might just jump ahead to that. I'm going to jump back to Creative Commons just in a moment. Here is exceptions to copyright. Non-commercial research, private study, critique, if you're quoting something for a review, absolutely education. I could actually use a lot more copyright images because I'm doing this for educational purposes, it's fine. All these other things. Thankfully, under UK law, caricature, parody is allowed, quotation, reasonable limits. Actually quite specific things around copyright that you can use. Anything not considered those things, you're better to proceed with caution. You're better to get permissions if you are using, particularly, especially an image off the internet or whatever. You're way better to kind of find the owner of the image. There are websites you can do that. Get permissions, pay a license, go to a company which licenses images, pay that license, because we're rewarding the work of the photographer, and I think that's fair enough in that example. So there are new forms of IP emerging. Creative Commons is a thing, but here's something really interesting. There is still a license involved. So you may go, like I've done, picked up a lot of images from Pixabay. All of my images here are Creative Commons. I'm still, when using the image, I'm still signing up to a license. The conditions just happen to be really, really generous. That is, the photographer has said, I'm fine for you to use my image for non-commercial purposes. I'm fine for you not to credit me. Or you can use it for non-commercial purposes so long as you credit me. There are different variations of Creative Commons. Always look at the details, but the same principle applies. the photographer in this example owns the work. They have rights over how that work is used. They license it. Open source software is similar principle. The source code becomes available to anyone who uses it. That's if you're a software developer. Oh yeah, George Orwell, one of the great novelists, 20th century British novelist. But 70 years after his death, rule applies, January of this year. Anybody can reprint, republish, adapt, put on a stage play any of his works this year because he's out of copyright. So any aspiring playwrights want to do something around one of his works, go for it, no problem. So a duplicated slide there. Related rights. This is where copyright gets really interesting. There are other related rights. There are things called moral rights, performers' rights, publication rights, database rights. You, as a creator of a work, not only have commercial rights, you have rights over your reputation. And this is really, really interesting. So every election campaign this happens. So with the Trump campaign, he was using, I think it was Aerosmith, a song from Aerosmith. The band objected to him using that because on the grounds of moral rights, we don't want to be associated with this campaign. We're asserting our moral rights because him using our song is damaging our reputation. It's used by association. We don't want to be associated with him. So this is another right enshrined in copyright law called moral rights, just so that you know. You have the right to protect your reputation with whatever you do. If you're performing in something, if you're a musician, an actor, a voiceover artist, you have performers' rights. Likewise, there's publication rights. If you find a diary never been published before and you got there first, you can publish that. And something called database rights, which is very obscure, but important nonetheless. How you manage data and information is a right. So I've got a few more minutes to go. Just wrapping up, this is real easy. Know-how and trade secrets. Know-how is what you know about your business, the thing that gives you your advantage. It might be the networks you have. It might be a skill like selling. It might be a mailing list that you have, a marketing list of some sort. All of this, a way of doing things which is better and more efficient than your competitor. That's your know-how. You keep that within the business. And perhaps if you're starting a business, you will have, I hope, some form of know-how or a skill that you can kind of trade off the back of. That's just naming it and you recognizing that that is a form of IP, and you can start your business potentially with that. And trade secrets, it's a method used a lot in food, beverage industry, you know, secret recipes around cakes or drinks of different kinds, Coca-Cola being the prime example. So just a couple of slides there around know-how, just so that you know, just underlining what I've just said, and a trade secret formula, whatever used in creating something. You don't file that, it's yours, you keep it secret, you use confidentiality, law of confidentiality, in order for that to apply to you. So in summary, why IP protection? Why am I here for an hour telling you about this topic? Hopefully it's got you interested more, it's whet your appetite. Hopefully this is going to be relevant to you as creatives and anybody starting a business or building a brand. All of these things are really important for you to be aware of. So why we do it? It protects your brand, your reputation. It rewards your creativity. Whatever you're creating in your business or as sole traders, whatever you create, you should be rewarded for that creation. It's only fair. It's your property. It monetizes your invention, potentially, or your creation. And that's super important as well. You need to earn. You should be able to earn off your work. And one thing I get quite passionate about is people in the creative industries really, they assert their rights, but they could do so even more. There's this culture whereby, oh, you're a sculptor, you're a painter or whatever. Oh, you know, your work is not as valuable, or you're a photographer. You know, it's commoditized. Absolutely not. As we've seen, a simple clock face can be worth $20 million. So never underestimate the power of what it is that potentially you are designing. Monetizes your invention creation, preserves your reputation, and helps you to stop others from misusing and using your work. Protects you from theft, basically. And that's a good thing, right? So I'll finish off with the power of a story. Cliche, I know, Star Wars, but one of the really earliest examples of licensing all these characters. It wasn't just a movie. 20th Century Fox owned the rights to the screenplay. Lucas owned the rights to the merchandising, everything that came off the back of that movie back in the late 70s. He was a pioneer. He formed Lucasfilm and eventually sold it to Disney for a huge, huge sum. He really cashed in. So all of the things around a story, the characters, the iconography, the music, everything, all under IP. I put here Elsa from Frozen. Elsa is something that I experience every day. I have a 3-year-old daughter. Everything is Elsa, 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 frozen, frozen, frozen. Frozen socks, frozen toothbrushes, frozen pajamas, frozen toys, of every kind of thing. It's crazy, it's nuts. All of that is IP. It's money going to the coffers of Disney Corporation. I'm just going to, okay. You know? But this is the power of IP. This is a company that's built off the back of it because they're a creative industry. They do the animation and everything off the back of it. They make more money off the toys than the movie. That's just the way it goes. So thank you for listening today. Here are some contact details. My name is Jeremy. Again, please feel free to email. I'm more than happy to have this deck sent around to you after today. Very happy to keep in touch. If you want to come into the British Library, you can register for a reader pass. We have a lot of information on marketing, company information, IP information, news, trends, analysis. You can come in and use us for that. I don't think we have time for questions. If I can sneak in a minute or two, I'll be glad to. But I don't want to spend more time than I'm allowed. Looks like I'm about to sneak in a question or two. Any questions? Happy to answer. Yes. Hi.
There are a lot of people who are actively against copyright
Yep.
stuff.
Yep.
And they found that in return, people will just copyright their stuff instead and get their money and stuff. And there's not a lot of system in place to help them, especially like people on YouTube and stuff.
Yep.
So do you think that we're actively being forced to copyright things and make it not fair for people who are really into fair use, which gets abused a lot by people who copyright their stuff, despite the fair use law being relevant?
You're absolutely right. So this raises a really interesting question around IP rights and who benefits from it. So in a way, there's an irony here. There's a real irony. You're absolutely right. The large companies are using copyright to their advantage, not allowing even the smallest use of their material to be used in a commercial context and so forth. And that is that's created a culture whereby copyright and IP is everything. That's just kind of the way that's what's happened. Now, it's a two-way street, but with a big caveat here. The same rights and law that a corporation has, in theory, you have the same rights too. So whatever, the same copyright system that works for them works for you. The point here is in the practice. Do you have the resources to fight a copyright case? That's where it comes down to a question of resourcing, and that's tricky.
There is, I found it interesting that even people like, I'm just going to throw out a name like the largest YouTuber, like PewDiePie, I don't know.
Yeah.
He can't even fight the copyright claims despite having a very large platform. So it feels very hard for everyone else who just doesn't have a platform at all, you know?
Yep. So there's an interesting thing here. So if his work is being used elsewhere without his permission, there's a kind of irony here as well, is that in a way his brand has been built and he's still earning off it in an indirect way by having his reputation spread.
Oh,
so,
I think I'm thinking of an example like his music was copyright free and then someone copyrighted it and he can't even get the revenue off of the videos. And he tried to dispute it and it just went away completely.
Okay, beg your pardon. Okay, yeah, so in that case, I would have thought he should have been able to shut that person down for commercializing it because he got there first. But in doing that, he'd be dragged into the copyright system to enforce his rights. Yeah.
I thought if you create something, then it's your intellectual property. So with or without a copyright, it's your intellectual property. Or
Yes.
is that not the case?
It is, yes. So copyright is one of the many forms of intellectual property. So it's one of the members of the family of IP. So yeah, we're talking the same thing.
What IP was?
Yeah.
Didn't
Yeah.
think that.
No, that's okay.
Hi.
Hi.
When you were citing the Coca-Cola imagery and the sort of vintage adverts,
Yes.
I think you sort of referred to them as trademarks. Would there not be an argument that they're public domain if they're old enough? Can you then sort of, I mean, is it possible to indefinitely trademark sort of public domain artwork prior to a certain era, or is there a sort of grey area?
Yeah. So it's a great question. So yeah, the older material from a company, the older it gets, there is a cutoff point, I think in US law, I think it's 100 years for corporate copyright. There is, in US law, there is something which allows public domain use. It's interesting with Disney. So the very earliest Mickey Mouse cartoons are now, in theory, out of copyright under this corporate exemption for 100 years or whatever. But they're being cheeky, clever, depending how you want to look at it. They're going down the trademark route to trademark the image of the old original 1920s Mickey Mouse. That's a way they're using the system to extend their rights. Yeah.
So would they be able to then trademark a whole animation?
Yes.
Is that not sort of stretching the definition of trademark? It sort of seems like quite a...
Yep.
It's unfortunate there's no sort of pushback
That's
legally.
stretching the definition. Absolutely.
Yeah.
Yep. That's what's happening. Great, everyone. Thank you for listening. Thank you. Nice to meet you all. Great. I'll hand back to, sorry, Seb, is it? Who's next?